This is lecture number 2, Forming the Attorney-Client Relationship. When do you have a client? What do you owe that client? How do you know when you have become someone's attorney? Here, the classic case of Togstad versus Vesely, Otto, Miller, and Keefe is instructive. In that case, Mrs. and Mr. Togstad went to a law firm to ask about a possible medical malpractice claim. They told their story to a lawyer at the firm. Then, Mrs. Togstad's story and the firm's story diverge. The lawyer claims that he told the Togstads that they did not have a case that his firm would be interested in taking. He said his firm were not experts in medical malpractice cases, but he would inquire whether another lawyer he knew would be interested in the case, and refer the case to his friend if his friend was interested. In the lawyer's mind, he was simply declining to take the Togstad's case. But Mrs. Togstad heard the lawyer give her a, quote, qualified quality legal opinion, quote, that they, quote, did not have a case. Based on this legal opinion, the Togstads took no action. Of course, sometime later, Mrs. Togstad went to another lawyer and discovered that they indeed had had a good medical malpractice case, except the statute of limitations had now run, so they couldn't sue the doctor. What could they do? Sue the firm of Vesely, Otto, Miller, and Keefe for legal malpractice. As you'll recall from torts, the first question in a negligence case is whether the alleged tortfeasor owed a duty to the injured party. Thus, the first question in the Togstad's legal malpractice case is whether such a duty was owed. In other words, whether there was an attorney-client relationship between the Togstads and the Vesely firm. And in answering this question, the court determined that yes, they did form an attorney-client relationship. Why? There was no letter of engagement signed, there was no retainer paid, there was no work done by the firm. What was the essence of the attorney-client relationship? The client was talking to the lawyer as a lawyer, looking for his expertise, and the lawyer was listening, and the lawyer responded to the client. And the client, relying upon the lawyer's advice, took no action. Here, the jury believed Mrs. Togstad's testimony that the firm had given her a qualified quality legal opinion that they had no case. So, the essence of forming the attorney-client relationship is communication and reliance. Client communicating to the lawyer her story or questions, and the lawyer replying with advice or an opinion under circumstances where the client would reasonably rely on the lawyer's advice. Note that because the lawyer is the agent for the client and owes a fiduciary duty to the client, the onus is on the lawyer to clarify the nature of the relationship. For class meeting, be prepared to role-play what the firm should have done in the Togstad case. The Togstad case is worth reading for a second reason. It sets forth the standard for legal malpractice. A lawyer may be sued for malpractice based either upon tort or contract. In either case, the plaintiff must show 1, that there was an attorney-client relationship, thus a duty was owed. 2, that the lawyer acted negligently or in breach of contract. And 3, that the lawyer's acts proximately caused the harm. In other words, made the client lose the case. And 4, but for the lawyer's conduct, the client would have won the case. In most cases, even if an attorney has been negligent, the client is unable to prove causation, to prove that she would have won. The malpractice client must prove the case within the case. Mrs. Togstad had to prove she would have won the medical malpractice case before she could win the legal malpractice case against the firm. Because the firm caused her to miss the statute of limitations, she lost what would have otherwise been a winning malpractice case. One final question before we turn away from the cautionary Togstad case. What rules are implicated? Which of the model rules determines when an attorney-client relationship has formed? What rule sets forth the legal malpractice standard? Answer: no rule. No rule in the model rules. Whether there is an attorney-client relationship is a matter of law, typically common law, in the jurisdiction. Likewise, the standards for malpractice are matters of state law, usually common law. And here I would like to refer you to the Restatement of Law Governing Lawyers. The restatement was written by the American Law Institute, the ALI, a prestigious group of attorneys. The restatement sets forth a series of principles or black-letter law. It analyzes and systematizes the law governing the practice of law. The restatement covers not only the rules of professional conduct, but also other areas of law that affect the practice of law, including tort doctrine relating to malpractice, vicarious liability, the work product doctrine, the attorney-client evidentiary privilege, and the agent-principal relationship. Regarding the topics for today, the Restatement of Law Governing Lawyers, Section 14, addresses when an attorney-client relationship is formed. It states that a lawyer-client relation arises when a person manifests to an attorney the person's intent that the lawyer provide legal services, and the lawyer consents to do so, or fails to manifest a lack of consent, and the lawyer knows or should know that the person reasonably relies on the lawyer to provide the services. Note how congruent that definition is with the rule in the Togstad case. Finally, before we turn away from the topic regarding the formation of an attorney-client relationship, I would be remiss if I did not mention Rule 118 in the Rules of Professional Conduct. Rule 118 is a relatively recently written rule dealing with the duties owed, quote, prospective clients. We will take up those various duties, from confidentiality to loyalty, when we cover those particular topics. For today, it is enough to know that the model rules now recognize the category of, quote, prospective client. Turning back to the Restatement of Law Governing Lawyers. The restatement also sets forth the standard for malpractice liability in sections 48 through 54. It provides that the duty of care requires the lawyer to exercise the competence and diligence normally exercised by lawyers in similar circumstances. The restatement further notes that violation of a rule does not itself give rise to a cause of action for professional negligence, but whether the lawyer's actions violated a rule may be considered in determining whether the lawyer exercised competence and diligence. Now let us turn to those rules, the model rules of professional conduct that require competence and diligence. Rule 1.1 deals with competence. An attorney always owes her clients competent representation. Competence requires, quote, the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation, close quote. Thus, competence is very case-specific. With respect to the legal knowledge and skills required, there are some cases that a novice can handle competently through preparation and study. There are other cases, perhaps an antitrust case or complicated intellectual property matter, that the general practitioner would not be competent to handle. In some cases, a novice can be competent through association with a more experienced attorney. In an emergency, a lawyer may give advice even if the lawyer does not have the skill ordinarily required, but he should limit the assistance to that reasonably necessary in the emergency. Competence also requires thoroughness and preparation, the preparation and study necessary for the particular case. More work will be required in a complex case and less work in a more simple case. For example, the Vesely firm was probably competent to handle the Togstad medical malpractice action in terms of knowledge and skill, but they did not act competently in giving Mrs. Togstad an opinion without adequate thoroughness and preparation, without doing any investigation. The typical standard of care in any local community would require some investigation, a minimum review of the medical record, perhaps consulting an expert, perhaps interviewing some witnesses, before expressing an opinion about the strength of a medical malpractice case. The most telling way in which the Vesely firm was not competent, however, was in failing to inform the Togstads of the statute of limitation. Rule 1.1, comments 6 and 7 deal with requirements when an attorney associates with another attorney outside her firm in order to provide competent representation to her clients. We will touch on those issues in future sections. Comment 8 points out that the lawyer must keep up with changes in the law, with technological change, and comply with any continuing education requirements. Most states require a certain amount of continuing legal education to maintain one's license. Rule 1.3 deals with diligence. The attorney is obligated to handle each matter with, quote, reasonable diligence and promptness, close quote. The comments flesh out what this means. Comment 1 points out that the lawyer should take whatever lawful and ethical steps are required to vindicate the client's case, despite personal inconvenience or opposition or obstruction by others. When the lawyer is an advocate in court, the lawyer should be zealous in that advocacy. However, the lawyer does not need to be a jerk. She need not press for every advantage. She has the professional discretion to determine the means, and she need not use offensive tactics or treat anyone with discourtesy or disrespect. Comment 2 states that the lawyer must control his workload so that all matters can be handled competently. Comment 3 points out that clients hate procrastination and that their interests can be adversely affected by delay. However, quote, a lawyer's duty to act with reasonable promptness does not preclude a lawyer from agreeing to a reasonable request for a postponement that will not prejudice the client, close quote. Comment 4 clarifies that the duty of diligence continues until the lawyer-client relationship ends. Just as with the formation of the lawyer-client relationship, it is the lawyer's responsibility to clarify for the client whether the relationship is ongoing. For example, a client who loses a case may assume that the lawyer will file an appeal. The onus is on the lawyer to consult with the client and clarify whether the lawyer will handle the appeal or whether the client should retain new counsel if an appeal is to be pursued. For solo practitioners, comment 5 is instructive. A solo practitioner should have a plan for another attorney to review her cases and take any immediate protective action needed in the event of the attorney's death or disability. On that note, we'll end this section and see each other in class. Thank you.